The morning ritual never changed. At precisely 5:30, before the sun had fully crested the eastern ridge, I would pull on my worn boots and heavy jacket, step out onto the porch my great-grandfather had built, and breathe in the crisp air of land that had sustained my family for 4 generations. The farm stretched out before me, 180 acres of rolling pasture, dotted with oak trees that had witnessed the passage of time alongside us. I walked the familiar path to the barn, gravel crunching beneath my boots. The structure, though weathered, stood strong against the elements, just as my family had done since 1932 when my great-grandfather purchased this land with savings from a decade of factory work. Inside, the gentle rustling of hay and soft lowing greeted me, a chorus I had known since childhood. "Good morning, ladies," I called out to my Belgian dairy cows. They turned their heads toward me, eyes curious and trusting. Bessie, the oldest at 12 years, approached first, her caramel-colored coat gleaming in the soft light filtering through the barn windows. I ran my hand along her neck, feeling the steady pulse beneath my fingertips. "Ready for another day?" I asked, knowing the answer. The milking parlor, modernized by my father in the 90s but maintaining its essential character, hummed to life as I prepared for the morning routine. Each cow entered in turn, familiar with the process that had remained largely unchanged despite technological advances. They were creatures of habit, much like myself. After milking came feeding, then maintenance checks on fences and equipment. By noon, with the morning chores complete, I would often take lunch on the eastern ridge, looking out over the seasonal creek that fed into the pond where the cattle gathered to drink. This land knew me as intimately as I knew it, every contour, every seasonal change, every blessing and challenge it offered. But recently, the view from that ridge had changed. Where once forest met sky at the horizon, now stood rows of identical houses, their terracotta roofs and beige siding a stark contrast to the natural landscape. Meadowbrook Estates, the sign proclaimed in elegant script. A planned community with all the modern amenities a family could want, according to the billboard that had appeared on the county road 6 months earlier. I did not begrudge progress. The county was growing, and people needed places to live. The development had been approved through proper channels, built on land that had once belonged to the Hendersons before they sold the farm and moved to Florida. What concerned me were the small changes I had begun to notice. The first sign came in the form of survey flags, bright orange markers fluttering along the eastern boundary of my property. I had checked my records, confirming that the line ran exactly where my grandfather had installed fencing in the 60s. Yet these markers stood 10 feet inside what I knew to be my land. Then came the visitors. 3 men in pressed khaki pants and button-down shirts, clipboards in hand, walking the perimeter of my property with measured steps. They introduced themselves as representatives of the Meadowbrook Estates Homeowners Association, newly formed to maintain community standards. "Beautiful operation you have here," the tallest one said, his eyes scanning the barn, the equipment, the cattle grazing in the distance. "Been in your family long?" "4 generations," I replied, offering them coffee from my thermos. They accepted politely, making small talk about the weather and crop prices. I thought little of it then. Neighborly conversation, nothing more. As they left, one glanced back at the cattle path that led to the pond. "That water feature visible from the development?" he asked casually. "The pond. Yes, it has been there since before my time. My cattle use it daily." He nodded, making a note on his clipboard. "Very picturesque," was all he said. 1 week later, I received the letter. The envelope arrived on a Tuesday, cream-colored paper with Meadowbrook Estates Homeowners Association, embossed in gold lettering across the top. I opened it at my kitchen table, the same solid oak surface where my family had shared meals for decades. The contents made my coffee turn bitter in my mouth. "Dear property owner," the letter began, formal and impersonal. "Following recent professional survey work, we must bring to your attention a boundary discrepancy affecting your property and the Meadowbrook Estates development." The letter continued with phrases like historical easement rights and community access priorities. But what stood out most was the clear claim that approximately 2 acres of my eastern pasture, including the pathway my cattle used to access water, actually fell within Meadowbrook Estates property lines. I set the letter down, my hand steadier than I expected. From the desk drawer in my office, I retrieved the leather portfolio my grandfather had given me when he transferred ownership of the farm. Inside were the original survey documents, property deeds, and every land record dating back to 1932. I spread them across the table, comparing boundaries and markers with painstaking attention to detail. The property lines were clear and unchanged. The eastern boundary followed the natural contour of the seasonal creek before extending north toward the county road. Every survey conducted since the original purchase confirmed these boundaries. The HOA claim had no foundation in fact or history. 3 days after receiving the letter, I was checking fence posts along the eastern boundary when a luxury SUV pulled up. A woman emerged, dressed in a tailored pantsuit that seemed entirely impractical for walking farm terrain. Her blonde hair was pulled back in a severe style that matched her expression. "Mr. Mitchell," she called, picking her way carefully across the field in designer boots that sank slightly into the soft earth. "I am Corinne Sheffield, president of the Meadowbrook Estates Homeowners Association." I wiped my hands on my jeans and extended one to her. "James Mitchell, what can I do for you, Miss Sheffield?" She ignored my outstretched hand, instead opening a leather portfolio similar to my own, though considerably newer. "I wanted to discuss our letter in person. I presume you have received it." "I have," I replied, retracting my hand, "and I have reviewed all historical property documents. There is no boundary discrepancy." Corinne smiled, though the expression did not reach her eyes. "Historical documents can be subject to interpretation, Mr. Mitchell. Our surveyors have identified clear markers indicating the boundary line runs approximately 15 meters west of your current fence line." She gestured toward my weathered fence posts. "Additionally, this livestock enclosure is non-compliant with community standards. The materials, height, and general aesthetic fail to meet the requirements outlined in our community bylaws." I blinked, momentarily speechless. "Ms. Sheffield, your community bylaws have no jurisdiction over my property. This farm predates your development by nearly a century. Adjacent properties impacting community sightlines fall under aesthetic review guidelines," she stated, as if reciting from memory. "Section 7, Paragraph 3 of the County Development Code." I had worked this land long enough to recognize when someone was trying to stake a claim that did not belong to them. The county code applies to new developments adjacent to existing structures, not to existing farms adjacent to new developments. The distinction matters. Corinne closed her portfolio with a snap. "Mr. Mitchell, I understand this must be difficult. Your rustic situation clearly holds sentimental value. However, Meadowbrook Estates represents a significant investment in modernizing this region. The community walking path planned for that strip of land will enhance property values for everyone, including yourself." The truth emerged. They wanted my land for a walking path. Not just any land, but the fertile strip containing the cattle trail to the pond that had watered my herd for generations. That evening, I drove to visit Frank Henderson, whose family had farmed adjacent land to mine for decades before selling to the developers. He sat on his porch, nursing a glass of iced tea, his weathered face solemn as I explained the situation. They pulled the same tactics with me, Frank admitted. Started with boundary disputes, moved on to complaints about farm smells affecting their model homes, offered below market value, knowing I was looking to retire. He sighed. Should have warned you they would come after your water access next. The following Tuesday morning, I spotted the small bulldozer parked at the edge of my property line. No operators present, but the machine sat there like a yellow metallic threat, keys dangling from the ignition. This was no misunderstanding. This was a calculated land grab, using intimidation tactics against what they assumed was a simple farmer without the resources or knowledge to fight back. They had severely underestimated both me and the legal protection afforded to century farms in our state. What they did not know yet was that my cattle had rights too, rights established long before the first shovel broke ground on their precious development. The feed store in town was 30 minutes from my farm, a weekly trip I had made every Thursday morning for years. That particular Thursday, I loaded bags of mineral supplement and a new salt block into my truck bed, exchanged local news with the owner, and headed back with the radio playing softly, thinking about the fence repairs needed in the north pasture. The dust cloud rising from my eastern boundary was visible from half a mile away. At first, I thought a fire had broken out, and my heart rate doubled instantly. As I drew closer, the reality proved equally alarming. 3 men in hard hats operated heavy equipment on land I had walked since childhood. A bulldozer pushed soil into small mounds, while 2 workers drove metal fence posts into the ground in a straight line, cutting directly through my cattle path to the pond. I slammed on the brakes, the truck skidding slightly on the gravel road before coming to a stop. Gravel sprayed as I accelerated onto the field, driving directly toward the construction site. The workers paused, looking up as my truck approached and stopped just yards from their equipment. "This is private property," I shouted as I exited the vehicle, not bothering to close the door behind me. "You have no authorization to be here." The oldest of the workers, a man with salt and pepper hair visible beneath his hard hat, reached into a plastic tube attached to the bulldozer and extracted rolled papers. "We have all proper permits, sir," he said, his tone respectful but firm. "Meadowbrook Estates HOA contracted us to install the community path barrier." He handed me the documents, which included county approval stamps and official seals. The permit authorized construction of a community walking path with safety barriers, along coordinates that cut directly through my eastern pasture. "These coordinates are incorrect," I insisted, pointing to the map attached to the permit. "This is Mitchell farmland, has been for almost 100 years." The worker shrugged sympathetically. "We just go where the permits tell us, sir. Any disputes need to be taken up with the county planning office or the property owner." "I am the property owner," I stated, my voice rising despite my efforts to remain calm. In the distance, I could see my cattle growing agitated. The Belgian dairy cows, normally placid creatures who followed daily routines with clock-like precision, paced nervously along their usual path, now partially blocked by the construction. The lead cow, Bessie, lowered her head, eyes fixed on the strange men and machines disrupting her territory. I pulled out my phone and began documenting everything, taking photographs of the equipment, the workers, the partially constructed fence, and the permit documents. The workers exchanged glances but continued their work, the mechanical groan of the bulldozer resuming as it pushed more soil. With shaking hands, I called the sheriff's office. Sheriff Taylor had known my family for decades, had even helped my father round up escaped cattle during the flood of '97. If anyone would understand the violation occurring, it would be him. 20 minutes later, his patrol car pulled up beside my truck. Sheriff Taylor, his expression grave beneath his department-issued hat, surveyed the scene before approaching me. "Jim," he said, nodding in greeting, "I see we have a situation here." I explained rapidly, showing him my property documents and the clear discrepancy between historical boundaries and the permits the workers carried. The sheriff listened, occasionally asking clarifying questions, before walking over to speak with the construction foreman. Their conversation was brief. When Sheriff Taylor returned to me, his discomfort was evident. "Jim, I sympathize with your position here, I truly do, but this appears to be a civil property dispute. The permits they have are officially issued by the county. I cannot order them to stop work based on competing property claims." "They are trespassing on my land," I insisted. "That has to count for something." Sheriff Taylor removed his hat, running a hand through thinning hair. "Property line disputes fall under civil law, not criminal. You need to file an emergency injunction with the county court." He placed a sympathetic hand on my shoulder. "I would do that today, Jim. Right away." Before I could respond, another vehicle approached, the now familiar luxury SUV driven by Corinne Sheffield. She emerged, designer sunglasses pushed atop her head, a rolled set of architectural plans under one arm. "Mr. Mitchell," she called, her tone falsely pleasant, "I see you have discovered our community improvement project. How wonderful." "This is illegal," I stated flatly. "You are building on my property without permission." Corinne unrolled the architectural plans across the hood of her SUV, gesturing for me and the sheriff to look. "These plans clearly show the Meadowbrook easement, established in 1974 when the county updated the water district boundaries. The easement grants access rights for development and community use." I had never heard of such an easement. "That is completely fabricated. My family has owned this land outright without easements since 1932. Corinne's smile remained fixed. "The documentation has been verified by county officials, Mr. Mitchell. The development has full legal rights to establish community access here." She tapped a manicured nail against the blueprint. "The walking path will enhance community integration with natural spaces, while the security fence will ensure proper separation between residential and agricultural activities." Our argument escalated, voices rising above the machinery noise. Sheriff Taylor attempted to mediate, suggesting again that I seek emergency legal intervention while reminding Corinne that disputed boundaries should ideally pause construction until resolution. Then came the sound that froze all conversation, a distressed bellow that carried across the pasture. Bessie, agitated by the disruption and cut off from her water access, had charged the partially constructed fence. The metal posts, not yet properly secured, gave way under her weight. A dozen other cows followed her lead, surging through the gap and onto the manicured landscape of Meadowbrook Estates. Corinne Sheffield's expression transformed from smug confidence to horror as 20 Belgian dairy cows, each weighing over 1,000 pounds, stampeded through the breach, heading instinctively toward their familiar watering spot, trampling freshly planted ornamental shrubs and tearing across pristine lawns in their path. "Control your animals," she shrieked, as if I possessed some magical ability to halt a cattle movement already in progress. Sheriff Taylor was already on his radio, calling for backup, while the construction workers stood frozen, watching the chaos unfold. I should have felt concern, perhaps even embarrassment, But in that moment, seeing Karen's carefully constructed plans literally trampled underfoot, I felt only a grim satisfaction. The battle lines had been drawn, not by me, but by my cows exercising their ancient right to water. The chaos unfolding before us was merely the opening salvo in what would become a much larger war. The certified letter arrived 3 days after the cattle incident. I recognized the law firm's name embossed on the envelope, one of the largest in the county. Inside, legal language detailed property damage claims totaling over $40,000 for landscape destruction, structural damage to community property, and emotional distress caused to residents. The HOA demanded immediate removal of all animals from disputed territories and threatened daily fines of $500 for any continued livestock encroachment. The final paragraph informed me that Meadowbrook Estates HOA had filed for an emergency injunction against my farm operations within 100 yards of their property line, effectively cutting off my cattle from their water source. My hands shook with a mixture of rage and anxiety as I placed the letter on my kitchen table. 4 generations of Mitchells had worked this land, respected it, maintained it according to practices that honored both tradition and environmental responsibility. Now some newcomers with expensive lawyers thought they could simply erase our boundaries and rights with threats and legal paperwork. I made a phone call to Eliza Sanderson, a semi-retired attorney who had handled legal matters for several local farms over the decades. Her office was located above the hardware store in town, the entrance marked by a simple wooden sign that had faded from years of sun exposure. The office smelled of old books, coffee, and the faint scent of peppermint that seemed to follow Eliza wherever she went. At 73, she moved more slowly than in her prime, but her mind remained razor sharp. She adjusted her reading glasses as she studied my documents spread across her desk, occasionally making notes in margins with a fountain pen that had belonged to her father. "They are overreaching," she said finally, looking up at me over the rim of her glasses. "But they are also well-funded and connected, which makes them dangerous." "Can they really take my land?" I asked, the question painful to even verbalize. Eliza leaned back in her chair, the leather creaking softly. "Not if we approach this correctly." She reached for a heavy law book on a nearby shelf, its binding cracked with age. As she flipped through the pages, she continued speaking. "Your cows have more legal rights than the HOA realizes." She turned the book toward me, pointing to a section titled Right to Farm Act with her pen. Our state enacted this legislation in 1983 specifically to protect established agricultural operations from encroachment by residential development. Her finger traced down the page. Under Section 4, traditional farm practices and operations are protected from nuisance claims when housing developments move adjacent to existing farms. "But they are claiming the land is theirs," I reminded her. Which brings us to water rights. Eliza pulled another book from her shelf. "The seasonal creek running through your eastern pasture is classified as a protected waterway under state environmental statutes. Your cattle's access to it is guaranteed under water rights dating back to territorial days." She opened her laptop, typing rapidly before turning the screen toward me. "Look at this satellite image. See how the creek feeds into the pond. That entire watershed is protected. Any construction affecting water flow or access requires extensive environmental impact studies." My spirits lifted slightly. Did the HOA file those studies? Eliza smiled for the first time since I arrived. "They did not. I checked the county environmental office records this morning after you called. No impact studies were submitted with their development plans." She closed the laptop decisively. That is their first major vulnerability. We worked late into the night, Eliza drafting a formal response to the cease and desist letter while I provided historical documentation of cattle paths, water usage, and farm boundaries. As the office clock struck midnight, she handed me a stack of papers. "File these first thing tomorrow morning," she instructed. "We are counter-filing for an emergency injunction against their construction, citing violation of the Right to Farm Act, water rights infringement, and failure to conduct mandatory environmental impact studies." I glanced through the documents, the legal language complex but the underlying argument clear. Will this stop them? "It will slow them down," Eliza replied honestly. "More importantly, it establishes our claim that your cattle have legal rights of passage and water access that predate and supersede HOA regulations." She removed her glasses, rubbing tired eyes. "James, you need to understand something important. This fight is bigger than just your farm. Across the county, agricultural lands are being swallowed by developments. If Meadowbrook gets away with this land grab, it sets a precedent that puts every family farm at risk." I nodded, the weight of her words settling heavily on my shoulders. This was no longer just about my property rights or my cattle's access to water. It was about protecting a way of life, an agricultural heritage that was increasingly under threat from those who viewed land only in terms of development potential. "The established pattern creates legal rights," Eliza emphasized, tapping the counter-filing. "Your cattle have been using that path to water for generations. In agricultural law, that matters more than whatever easement they claim to have discovered." As I drove home under a canopy of stars, the same stars that had witnessed my great-grandfather's first night on this land, I felt a resolve harden within me. The HOA had resources and connections, but I had something more powerful: the law protecting a way of life that had sustained not just my family but the entire region for generations. My cows did indeed have legal rights, rights that Karen Sheffield and her homeowners association were about to discover in ways they never anticipated. The Meadowbrook Estates clubhouse stood at the center of the development, its architecture a blend of contemporary and faux farmhouse elements that attempted to invoke rural charm while maintaining modern luxury. Tonight, its parking lot overflowed with vehicles, residents gathering for what the community bulletin had described as an emergency meeting regarding agricultural boundary issues. I parked my truck between a Mercedes SUV and a Tesla, the dirt and mud splatter on my vehicle a stark contrast to the polished exteriors surrounding it. Taking a deep breath, I straightened my collar and entered the building. The conversation in the crowded meeting room halted abruptly as I stepped through the door. Heads turned, expressions ranging from curiosity to outright hostility. I recognized few faces, most residents having moved in after construction completed 6 months earlier. I nodded politely and took a seat in the back row, acutely aware of my worn jeans and work boots among the business casual attire of the homeowners. At the front of the room, Karen Sheffield stood at a podium, a projection screen behind her displaying an aerial photograph of my farm with red circles highlighting the disputed boundary area. She tapped a microphone, calling the meeting to order. "Thank you all for coming on such short notice," she began, her voice carrying the practiced cadence of someone accustomed to public speaking. "As many of you have heard, we are facing a significant challenge to our community development plans from the adjacent agricultural property." She clicked a remote, changing the image to show my cattle grazing near the boundary line. "This eyesore threatens our property values and community aesthetic," she continued. The proposed walking path would create a proper buffer zone while enhancing community amenities. I clenched my jaw as she described my multi-generational farm, as if it were an illegal dumping ground, rather than a working agricultural operation that had existed long before their houses were built. Furthermore, last week we experienced a disturbing incident when unsecured livestock invaded community property, causing extensive damage to landscaping and creating potential safety hazards for residents. Murmurs spread through the crowd as Corinne clicked to photographs of hoof prints across manicured lawns and trampled ornamental bushes. I noticed several residents glancing back at me, expressions hardening. The HOA board has unanimously approved allocation of funds to address this situation through appropriate legal channels, Corinne announced. Our attorneys have filed for an emergency injunction to prevent further damage to community property while property line disputes are resolved. My stomach churned as I considered my options. I had planned to listen quietly, to gather information rather than engage directly. But the mischaracterization of both the situation and my farm demanded response. I shifted in my seat, preparing to stand when Corinne opened the floor for comments. Before I could rise, something unexpected happened. A silver-haired man in the third row stood up, adjusting his glasses as he addressed the room. "Point of order," he said, his voice carrying the gravitas of someone used to being heard. "I believe we should consider what we are actually voting on here before proceeding. My family purchased in Meadowbrook specifically because we wanted to live near farmland, not eliminate it." Corinne blinked, momentarily thrown off script. "Mr. Davidson, while your sentiment is understood, the issue at hand is property rights and community safety." "Is it?" Mr. Davidson countered. "Because it seems to me we are talking about spending $50,000 of HOA funds to fight a boundary dispute with a farm that was here long before our houses were built." Murmurs rippled through the crowd again, but different this time. A young mother near the front raised her hand and spoke without waiting to be acknowledged. "My children love watching the cows," she said. "It is one of the reasons we chose this location instead of the development across town. The real estate brochure actually advertised pastoral views as a selling point." Corinne's carefully orchestrated presentation began to unravel as more residents voiced similar opinions. The meeting devolved into heated exchanges between neighbors, revealing a community deeply divided over its relationship with the surrounding rural landscape. "Property values are the priority," insisted a man in a business suit, standing to address the room. "Unregulated agricultural activities adjacent to luxury homes depress market value. The buffer zone is necessary." "We moved here from the city to experience country living," countered an older woman. "If we wanted sterile landscaping and no connection to agriculture, we could have stayed in our condo downtown." I remained silent, watching the community fracture before my eyes. Though I had entered feeling isolated, I now realized that many Meadowbrook residents valued the farm's presence and were uncomfortable with their HOA's aggressive tactics. The division made local news by morning. The Evening Chronicle ran a front-page article titled "Century Farm Fights HOA Land Grab," featuring photographs of my cattle and quotes from residents on both sides of the dispute. The reporter had done her homework, noting the farm's historical significance and raising questions about the HOA's development claims. As public sentiment began shifting, Corinne and the HOA board grew more aggressive. At an executive session closed to residents, they allocated an additional $50,000 for legal fees and hired a public relations consultant to manage community messaging. The battle lines extended beyond legal filings and property disputes. Someone began a whisper campaign questioning my farming practices, suggesting that my operation posed environmental risks to the watershed. Anonymous complaints to the County Agricultural Board prompted surprise inspections of my property, all of which found no violations. Then came the signs. I discovered them one morning along my property line, crude handmade placards staked into the ground reading, "No farmers, no farms, and city progress over country problems." The message was clear. This was no longer just about land, but about competing visions for what the community should be. What began as a boundary dispute had evolved into something far more profound, a microcosm of the tension between agricultural heritage and suburban expansion, playing out across rural America. Each side believed deeply in the righteousness of their position, seeing the other as a threat to their way of life. In the middle stood my cattle, creatures of habit and instinct, still attempting to follow their ancestral path to water despite the obstacles humans had placed in their way. Their persistence served as a living reminder that some things, some rights, transcended property disputes and development plans. The lines had been drawn, the community divided. The next battlefield would be the county courthouse, where generations of land disputes had been settled before ours and would continue long after our particular conflict was resolved. The county courthouse stood at the center of town, its imposing marble columns and granite steps a testament to the permanence of law in an ever-changing world. Built in 1892, it had witnessed the transformation of our region from frontier territory to modern county, its courtrooms adjudicating everything from cattle rustling in the early days to complex property rights cases in the present. Today, it would hear our case. I arrived early, dressed in my best suit, the same one I had worn to my father's funeral 3 years earlier. Eliza Sanderson met me on the courthouse steps, her silver hair neatly styled, carrying a weathered leather briefcase stuffed with documents. "Ready?" she asked, her eyes sharp behind tortoiseshell glasses. "As ready as I will ever be," I replied, straightening my tie. We entered the historic building together, our footsteps echoing on the marble floors as we made our way to Courtroom 3. Inside, the wood-paneled room smelled of lemon polish and tradition. We were the first to arrive, claiming a table to the right of the judge's bench. Eliza arranged our evidence methodically, stacks of weather-worn farm records and survey maps spreading across the surface. 20 minutes later, the courtroom doors opened again. Karen Sheffield entered, flanked by 3 attorneys in expensive suits, each carrying leather portfolios and digital tablets. They took their positions at the table opposite ours, the contrast immediate and intentional, their modern technology and polished appearance against our paper records and modest resources. As the courtroom filled with spectators, including several Meadowbrook residents and local farmers who had come to show support, the bailiff called the room to order. Judge Eleanor Martinez entered, her black robes flowing as she took her seat at the bench. A descendant of ranchers who had settled the region in the 1800s, Judge Martinez had a reputation for fairness and no-nonsense efficiency. Case number 2025 CV4873, Mitchell vs. Meadowbrook Estates Homeowners Association, the bailiff announced. Emergency injunction hearings. The lead HOA attorney spoke first, his voice carrying the polished delivery of someone who charged $500 per hour for his expertise. He outlined the HOA's position methodically, emphasizing property values, community aesthetics, and modernization of county infrastructure. "Your Honor, the development plan in question represents a $3 million investment in community enhancement," he explained, gesturing to architectural renderings displayed on a large screen. The proposed walking path would not only serve Meadowbrook residents but eventually connect to the county trail system, providing recreational opportunities for all citizens. The presentation continued with satellite imagery, property surveys conducted by the development company, and testimony from a real estate valuation expert regarding the impact of agricultural operations on adjacent residential property values. Furthermore, the attorney concluded, the historical easement documentation clearly grants access rights through the disputed territory for community development purposes. We ask the court to deny the plaintiff's request for injunction and allow this valuable community improvement to proceed as planned. When our turn came, Eliza approached the bench with calm confidence. Rather than matching their technological display, she simply set up a small projector borrowed from the public library and played the video I had recorded of my cattle's daily trek to water, following the same path worn by generations of hooves. "Your Honor," she began, her voice steady, "what you are witnessing is not merely animals walking to water. You are seeing a legally protected agricultural practice that predates the Meadowbrook development by nearly a century." With methodical precision, she outlined the state's Century Farm Protection Statutes, water access rights established under territorial law, and environmental regulations protecting established agricultural practices. The courtroom remained silent, captivated by her clear explanation of complex legal principles. Additionally, Eliza continued, we submit documentation proving that the HOA failed to conduct mandatory environmental impact studies required under state law when construction might affect agricultural water access or protected watersheds. She displayed county maps identifying the seasonal creek on my property as a protected tributary. This waterway has been recognized as environmentally significant since the Water Protection Act of 1987, requiring specific permits and studies before any construction can impact water flow or access. No such studies were conducted, making their permits invalid on their face. Judge Martinez studied both arguments carefully, occasionally asking clarifying questions about water rights precedents and environmental protection statutes. After 3 hours of testimony, she removed her glasses, addressing the courtroom directly. Based on the evidence presented, this court grants an emergency injunction against further fence construction, pending full environmental and agricultural rights review, she declared. The defendants are ordered to halt all construction activities within 100 yards of the disputed boundary until proper environmental impact studies can be conducted and reviewed by appropriate agencies. Outside the courtroom, reporters gathered on the courthouse steps. The State Environmental Protection Agency had issued a statement announcing an investigation into Meadowbrook's construction activities near the protected waterway. Public interest in the case had grown beyond our small community, becoming emblematic of the tension between development and agricultural preservation throughout the region. Most damaging for the HOA was the revelation published in that evening's newspaper. A local journalist had uncovered that Karen Sheffield's husband served as vice president at the very development company contracted to build the community walking path, a clear conflict of interest never disclosed to HOA members. The article questioned whether the aggressive pursuit of the boundary dispute was motivated by community interests or private financial gain. As Karen hurried past cameras toward her waiting SUV, her carefully constructed facade began crumbling under the weight of public scrutiny. The tide had turned, at least temporarily, in favor of century-old agricultural rights over modern development ambitions. The battle was not yet won, but for the first time since finding survey stakes on my property, I felt the scales of justice beginning to balance. 6 months after the emergency injunction, we returned to the same courtroom for the final ruling. The intervening time had brought significant changes to both the farm and the Meadowbrook community. The environmental investigation had uncovered multiple violations in the development's permits. The State Agricultural Board had intervened, filing supporting briefs emphasizing the importance of protecting established farming operations from encroachment. Judge Martinez entered the courtroom, her expression as inscrutable as during our first appearance. The room fell silent as she took her seat, arranged her papers, and looked out at the assembled parties.